Delphi update. Indiana Supreme Court is involved. On November 6, 2023, a group of attorneys filed another original action in the Indiana Supreme Court against the trial judge in the Delphi case. This original action is called the Writ of Mandamus and is a relatively rare thing. This mandamus is literally going to the Indiana Supreme Court to complain against the actions taken by the trial judge. This is very rare and not something to bring up lightly. In fact, the Indiana Supreme Court in the rules flat out says original actions are disfavored and not a substitute for appeal. So this original action against the Delphi trial court judge alleges three things. Number one, the trial court judge has no power to simply remove attorneys from a case. Number two, as the original defense team was ready for trial, the Supreme Court needs to order a trial to commence within 70 days. Number three, the Indiana Supreme Court needs to remove the trial court judge and appoint a new judge in this matter. Let's walk through these. Now, this is the action I wanted to see. The one filed last week dealt with public records. Of course those should be public. They should have been public months ago. Now, I've done appeals, but I don't consider myself to be an appellate attorney, so I'm not comfortable making a video saying, why didn't these attorneys file something January, February, March to make these records public? Maybe there are good reasons, but I don't know. But this second writ of mandamus, the new one, this is something I'm pretty familiar with. So let's walk through this. Number one, the trial court has no authority to simply kick attorneys off cases. This is basic law school 101. In America, you get to choose who your attorney is. And sometimes people make terrible choices about who they hire. I see this all the time in criminal court. I see family law attorneys walking into court with criminal clients. I see trust and estates attorneys walking into court representing a criminal client. I ask them, what are you doing? And they'll say things like, oh, hey, Mark, I don't practice criminal defense, but I'm doing it as a favor to my client or a favor to my friend. Lawyers that just hop into criminal law when that's not their normal practice area are not doing a favor to their client or friend. They're doing a favor to the prosecutor by making an easy case for the government. And this doesn't happen only in criminal law. I have an injury partner, Jamison Allen. Guy is a complete rock star. Every day he sees some random attorneys handling serious crashes for hurt people. He asks them, what is going on? And they'll say, oh, I'm just doing a favor for a friend or a favor for a former client. No, they're not doing anyone a favor practicing an area of law they know nothing about. The only person they're doing a favor for is the insurance company when they accept a low ball offer. But guess what? This is America. People get to choose who represents them so long as that person is a licensed attorney. And people pick wrong all the time, but that's their right. There's only two ways the judge can kick an attorney off the case, and only two. Number one, the attorney is not a member of the state bar. So the attorney shows up, well, I'm representing so-and-so, and the judge sees the person is not licensed in Indiana, but maybe Oklahoma. The judge gets to kick that attorney off the case, and that's fine. But there are even ways around this. It's something called a pro hoc vice, but that's super boring. We're not going to talk about it. The second way a judge can kick someone off the case, if there's a conflict of interest. A conflict of interest can get complicated and messy, but the idea is very simple. If an attorney's allegiance would or even could be compromised representing two different people, then the attorney is conflicted off a case. The easy example is two bank robbers come into my office and try to hire me to represent them both. Well, I can't, because the first bank robber's best defense is to blame the second bank robber, and the second bank robber's best defense is to likely blame the first bank robber. I couldn't zealously defend both. If a judge sees a conflict like this, a judge can order an attorney removed. But there are even ways around this conflict of interest. Now, that's it. The power of a trial court judge to kick an attorney off a case is extremely limited. So what's going on with gross negligence, though? Hey, I see gross negligence all the time in court. I see attorneys telling clients to plead guilty to crimes that the attorney has no idea will impact the client's driver's license, that the person is going to be stuck a felon for the rest of their life, or even that there's mandatory jail days. And I don't think it's right, but this is America, and people can choose to hire terrible attorneys. Now, I don't agree that the original defense team was grossly negligent, but even if they were, that's not grounds to kick them off the case. But Mark, there was an evidence leak. A trusted friend of Attorney Baldwin came into Attorney Baldwin's office and took a picture of some evidence laid out on a conference room table. Yeah, maybe Attorney Baldwin shouldn't have had a good friend who trusted come into his office, But even saying that out loud sounds stupid. The guy who did the evidence leak had a law degree, was good friends with Attorney Baldwin, and that person admitted he violated Attorney Baldwin's trust by taking a picture of crime scene evidence. The guy admitted to theft. Generally, a person is not responsible for the criminal acts of another person. I don't see how Attorney Baldwin is in any way, shape, or form responsible for the criminal act of another human being, especially one that he has known for a long time and is considered a trusted friend. The bottom line is, once a judge appoints an attorney or a person hires an attorney, there is very little a judge can do to remove that attorney. And that's how the system is designed. A judge should not be able to kick an attorney off simply because they don't like how the attorney is handling the case or doesn't agree with strategy. I think the Indiana Supreme Court will agree with this point and put Baldwin and Rosie back on the case. The second thing in the writ of mandamus is that Richard Allen wants a speedy trial. He does not want to wait until October 2024. They want the trial within 70 days. The only way the trial can happen that quickly is by getting the original defense attorneys back on board. This case is already old, and apparently there is some evidence that the original attorneys told the court and prosecutors they intended to go forward with the trial in January, and they even wanted to file a speedy trial request to enforce that January trial date. The Indiana Supreme Court can simply avoid this entire issue by reinstating the original defense team, and then the original defense team can request a speedy trial. The third issue in the writ of mandamus is asking the Indiana Supreme Court to remove the trial court judge, as the trial court judge has publicly stated Richard Allen's attorneys are grossly negligent, and the trial court has grave concerns about the representation. Two problems with this. The judge publicly stating this, well, the judge obviously doesn't believe that Baldwin and Rosie are doing a good job. Now, this is prejudicial to Richard Allen because if the judge doesn't like the attorneys, that will absolutely bleed into how the judge perceives Richard Allen and Richard Allen's defense. In addition to prejudicing the attorneys, the public will also question the judge's impartiality of all rulings in this high-profile case. And if the public is questioning the judge's impartiality, then that very well can undermine the public's perception and the validity of the legal system. And that is bad. Now, I bet the trial court judge probably would not be too upset if she were kicked off this case at this point. Because, man, this is a high-drama case. And who needs all that drama in their life? Especially for a case that's not even in her home county. Now, I have no idea what the Indiana Supreme Court is going to do on removing this judge. I do feel like, in a technical point, if the Indiana Supreme Court puts Baldwin and Rosie back on the case, how can they not assign a new judge? The judge has publicly said they're doing a bad job. Could you imagine being fired from your job by your immediate supervisor? Then your supervisor's boss says, nope, you're back on the case. And then you have to work with your original boss again? That is the definition of a toxic work environment. I mean, I think it would be awesome to watch as an outside observer, might even make a cool legal TV show, but this is real life, and a real person has to deal with however this case comes out. The response briefs are due on November 16th. I will try to get an update after that. I am super excited to see where this crazy case takes us. You never know where the Delphi case is going to go. If you have any questions, leave them as a comment. I will try my best to respond to all comments. There are two important points in closing. Richard Allen is innocent until and unless he is proven guilty in a court of law. And remember, always plead the fifth. Now, if you watched this video this far, please like this video and subscribe to my channel. I would really appreciate it. Thank you.